You know, in the old days, we used to see on TV the follow the bouncing ball. You remember that, Mr. Producer? Well, we don't have a bouncing ball, but if we did, I'd use it because I want to walk you through something that nobody has done before. So you will be fully informed about what's taking place on this January 6th case in Washington, D.C. And I think by the time I'm done, you're going to be shaking your heads in disbelief. So it's not going to be the usual static you hear, the surface level politics you hear, and all the rest. Let's dig in. And specifically, I want to dig in on the judge, Judge Tonya Chutkan. This is very, very important. So let's start with the facts. Let's start with the law. There's something called the Code of Conduct for United States judges. Did you know that existed? So they have a code of conduct for United States judges, just as they have them for lawyers and they have them for doctors, they have them in other professions, and the judges are compelled to comply with it. So I'm here to make the case that Judge Tonya Chutkan is unqualified as a federal judge to handle the January 6th case, and in fact, really is unqualified to be a judge of any kind. That's pretty harsh, but it's exactly correct. Here it is, the Code of Conduct for United States judges. This isn't optional. This is required. The judge must follow it. I want to read some of it to you. Canon 1, an independent and honorable judiciary is indispensable to justice in our society. A judge should maintain and enforce high standards of conduct and should personally observe those standards so that the integrity and independence of the judiciary may be preserved. The provisions of this code should be construed and applied to further that objective. Deference to the judgment and rulings of courts depends on public confidence in the integrity and independence of judges. The integrity and independence of judges depend in turn on their acting without fear or favor. Although judges should be independent, they must comply with the law and should comply with this code. Adherence to this responsibility helps to maintain public confidence in the impartiality of the judiciary. Conversely, violation of this code diminishes public confidence in the judiciary and injures our system of government under the law. The canons are rules of reason. They should be applied consistently with constitutional requirements, statutes, other court rules, and decisional law, and in the context of all relevant circumstances. The code is to be construed so it does not impinge on the essential independence of judges to make judicial decisions. Now, it goes on. I'm reading the relevant sections. This is Canon 2A. A judge must expect to be subject to constant public scrutiny and accept freely and willingly restrictions that might be viewed as burdensome by the ordinary citizens. Because it is not practicable to list all prohibited acts, the prohibition is necessarily cast in general terms that extend to conduct by judges that is harmful, although not specifically mentioned in the code. Actual improprieties under this standard include violations of law, court rules, or other specific provisions of this code. Goes on. Canon 3A3. The duty under Canon 2 to act in a manner that promotes public confidence in the integrity and impartiality of the judiciary applies to all the judge's activities, including the discharge of the judge's adjudicative and administrative responsibilities. The duty to be respectful includes the responsibility to avoid comment or behavior that could reasonably be interpreted as harassment, prejudice, or bias. The Code of Conduct for United States judges. Now, let's apply it. In realclear.com, Julie Kelly writes about what took place in the first hearing on determining the date for the trial of the January 6th case. And she writes in part, having gone through 1,000 of this judge's decisions with respect to January 6th defendants, as well as the case involving Donald Trump, she says Chutkan has routinely issued politically charged rulings and made incendiary statements of her own while presiding over some 30 cases involving Trump supporters charged in connection with the January 6, 2021 melee at the U.S. Capitol. She writes, a review of thousands of pages of hearing transcripts, which she did, reveal that Chutkan has repeatedly expressed strong and settled opinions about the issues at the heart of the U.S. v. Donald Trump, the criminal case she is now presiding over. These include her public assertions that the 2020 election was beyond reproach, that the January 6th protests were orchestrated by Trump and that the former president is guilty of crimes. She has described January 6th as a mob attack on the very foundation of our democracy and branded the issue at the heart of the case she's her hearing, Trump's claim that the 2020 election was stolen, as a conspiracy theory. These are all opinions that had nothing to do with what's before this judge. And she's spewed all these editorial comments and these essays, particularly during the sentencing period of these various trials. Although judges often make comments from the bench, Chutkan's strident language raises questions about her impartiality in handling the case against the presumptive GOP nominee for president in 2024. The U.S. code that addresses grounds for recusal states, any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might be reasonably questioned. One reason to recuse is if the judge has demonstrated a personal bias or prejudice concerning a party. She has, over and over and over again. On at least one occasion, Chutkan suggested in open court that Trump should have been charged for his alleged role, what she routinely describes as an attempt to overthrow the government on January 6th, before sentencing Christine Priola, a Trump supporter from Ohio who pleaded guilty to obstruction of an official proceeding, to 15 months in jail. Chutkan appeared to lament the fact that Trump was not yet in prison. Quote, she said, the people who mobbed the Capitol were there in fealty and loyalty to one man, not to the Constitution, of which most of the people who come before me seem woefully ignorant, not to the ideals of this country, not to the principles of democracy. She said on October 28, 2022, it's a blind loyalty to one person who, by the way, remains free to this day. Chutkan accused Matthew Mazzocca, another January 6th defendant, of choosing Trump over the country and rejecting his argument that he traveled from Texas to Washington to engage in a legal political demonstration. Chutkan declared at his October 2021 sentencing hearing, quote, he went there to support one man who he viewed had the election taken from him. In total disregard of a lawfully conducted election, he went to the Capitol in support of one man, not in support of our country, in support of democracy. In the case of Robert Palmer, at sentencing, Chutkan said, here, listen to this one. Mr. Palmer, you have made a very good point, one that has been made before, that the people who exhorted you and encouraged you and rallied you to go and take action and to fight have not been charged. That is not this court's position. I don't charge anybody. I don't negotiate plea offers. I don't make charging decisions. I sentence people who have pleaded guilty or have been convicted. The issue of who has or has not been charged is not before me. I don't have any influence of that. I have my opinions, but they are not relevant. And you're correct in that no one who was encouraging everybody to take the Capitol has been charged as of yet. But I don't think that fact means that you should get a lower sentence. There's so much. Throughout the 45-page indictment, Smith, that is the prosecutor, repeatedly accused Trump of knowingly promoting falsehoods about the 2020 presidential election. So you can see the judge sounds like the prosecution. For more than 2 months following the election day, November 3, defendant spread lies that there had been outcome determinative fraud in the election. He had actually won. These claims were false, and the defendant knew that they were false, but the defendant repeated and wildly disseminated them anyway to make his knowingly false claims appear legitimate, create an intense national atmosphere of mistrust and anger, and erode public faith in the administration of the election. That's Smith talking about Trump. Now, Chutkan clearly shares that view. On many occasions, the judge has insisted the 2020 election was legitimate and fully vetted by the court system, a claim disputed by Trump that lies at the heart of the case she is now hearing. Now, ladies and gentlemen, there's case after case after case in the sentencing part of these trials or these plea agreements where Chutkan comments on the election, comments on what took place, makes comments about Trump, either directly or in an ambiguous way, but is intended to raise the fact that it's Trump. You can tell she has an incredible, intense animus towards Trump, and she's supposed to be the judge. More. The judge set the date for March 4th for the trial. Your Sixth Amendment requires that you have effective representation of counsel. that you're not just going through the motions. And at the very end of it, it says, and to have the assistance of counsel for his defense. So what did the judge do? She set an impossible trial date. Impossible trial date. President Trump's lawyer was in court that day, and he said to the judge that this date means that my client will not get an effective representation of counsel in violation of the Sixth Amendment. That the prosecutors are talking about 12.8 million pages of documents, God knows how many videos and other information, and that doesn't include all the work we have to do with documents we want to present, testimony we want to present, and so forth. And by making the date March 4th, you're giving us effectively 5 months to prepare for a trial with millions of pages of documents in a case the kind of which has never been brought before, that has constitutional complexities. And not only that, ladies and gentlemen, she picks the date right before Super Tuesday because she wants it to have maximum impact. And it's worse than that. We have memos from attorneys general, Republican and Democrats, and they say to prosecutors in their department, here they are, they're right in front of me. We have one from Attorney General Michael Mulcahy, March 5, 2008. We have one from Attorney General Eric Holder, March 9, 2012. We have one from Attorney General Loretta Lynch, April 11, 2016. They all say the same thing. Politics must play no role in the decisions of federal investigators or prosecutors regarding any investigations or criminal charges. Law enforcement officers and prosecutors may never select the timing of investigative steps or criminal charges for the purpose of affecting any election or for the purpose of giving an advantage or disadvantage to any candidate or any political party. This is the official position and has been of the United States Department of Justice for decades. So the special counsel purposely brings 2 criminal charges right in the heart of a Republican primary in a presidential election, working for the opposition party, the president being Biden, of course, for maximum political impact. But it's worse. Judge Chutkan goes even further. She sets March 4th, the date, specifically intended to cripple Donald Trump's campaign by setting the beginning of the trial for the day before Super Tuesday, the most important primary day for Republicans on the calendar. Not only that, Judge Chutkan jumped the line. The first federal case brought was the case that's in Florida. Judge Cannon's in charge of that case. Weeks before Judge Chutkan set the trial date for March 4th, Judge Cannon already set the trial date for the first federal case in May. So when she issued an order setting March 4th as the initial trial date for the second Smith case, Chutkan created great difficulties not only for the Trump legal team violating their Sixth Amendment rights, because there's no reason to have this trial on March 4th. There's no reason to have this trial this year. She intentionally undermined Judge Cannon's May order for her trial and all the issues related to that in the document case. She jumps in front. Chutkan is so extremely political and radical. She wanted to make sure she could get her case January 6th before a Democrat D.C. jury as fast as possible, help the Department of Justice, the prosecutors, get a conviction, so Trump is branded for the rest of the election as a convicted felon. He may have incredibly strong arguments on appeal, like her violation of the Sixth Amendment, like her violations, in my view, of the Judicial Code by interfering with an election, purposely so, like her treatment of the defendants and so forth, but it won't be heard in time on appeal to have any impact on the election. So she knows she can do virtually anything at the trial level, virtually anything. She wants Donald Trump branded as a convicted felon, so reprobates and opportunists like Chris Christie can run around rather than condemning the Stalinist-type situation that's going on, say Donald Trump can't run for president. He's too busy defending himself in the court, which is exactly why past attorneys general said, you're not supposed to do this. I hope this all makes sense to you. The bottom line is this. Judge Tonya Chutkan is absolutely not fit to be the judge in this case. She's already demonstrated that. She's created a very diabolical situation by jumping the line on the first case. We also know when she set that date on March 4th, she had already talked to the judge in the case of Manhattan. She already had made up her mind that she was going to pick March 4th. And she's not a fool. Doesn't mean she's a good judge, but she's not a fool. She knew exactly what she was doing. Denied Trump and his lawyers the Sixth Amendment due process rights, denied Trump effective representation to counsel. He wants to appeal it. He'll appeal it later. Set a date that interferes with the trial date in Florida. Obviously, I doubt she called Judge Cannon in Florida like she called the Democrat judge in New York. So she jumps the line because she wants to get her case going first. Why? She wants to interfere with the primaries as much as she possibly can. That's the date. And on top of that, she wants Trump convicted of something, so he's treated as a convicted felon by fellow Republicans and Democrats in the course of the election. That's Judge Chutkan. Now, Judge Chutkan, you need to step down. And somebody who has the authority, like the chief judge or the D.C. bar, if she doesn't step down on her own, then you need to tell her to step aside. This is worse than the appearance of a conflict. This is a conflict, a grotesque conflict.
Want to see more Mark Levin? Go to LevinTV.com and subscribe now.